deep into the latest developments in the world of European patent litigation. I'm your host, George Walden. Glad you could be here. Today, we're tackling one of the most dynamic and high-stake tools in the UPC arsenal, preliminary injunctions. Are they fast? Are they predictable? And what do early decisions tell us about how the UPC balances urgency, validity, and proportionality? Joining me are two highly experienced UPC representatives. First, before I get into it, let me introduce our first guest. His name is Jasper, and he works in all fields of industry property law, particularly patent, trademark, and design prosecution. He also has experience in opposition and nullity proceedings and works on complex litigation cases. His field of work also covers the creation of expert opinions on the validity and infringement of IP rights. And he is also one heck of a talented musician. Ladies and gentlemen, please welcome back to the show, Mr. Jasper. Jasper, welcome back, buddy.
Thank you, George. Great to be back.
We also have a man who needs no introduction, but who deserves the utmost praise for his work and extensive knowledge concerning the Unified Patent Court, past and future developments. He also helps to produce the UPC Insights show, and he's also a friend and a colleague, Mr. Tilman Pfrang. Tilman, welcome back, buddy.
Hi, George.
So, ladies and gentlemen, I know you're ready to get started. So, Jasper, let's start with you first. Could you briefly explain what makes the preliminary injunction procedure before the UPC particularly interesting or different compared to national systems?
Sure, George. The main thing that comes to mind, of course, is the territorial scope of a preliminary injunction before the UPC. It's possible to get an injunction that is enforceable in all UPC member states in which the patent issue is in force. So this is really a cross-border injunction. It's something new to Europe that we have not seen before the introduction of the UPC. And the big scope is what makes it highly attractive. I mean, a preliminary injunction is a very sharp sword in the toolbox of patent law anyways, but now being able to really enforce such a decision across borders in Europe is really what makes it super interesting for patent holders. And from what we have seen so far, now almost 2 years since the launch of the UPC system, the system works really well. The application process is super effective. Some of the injunctions that we have seen have been granted within the same day, if properly prepared, so it's a very strong weapon for the patent holder. As of the end of February 2025, we've seen close to 60 preliminary injunctions that were applied for. Roughly 50% of them were granted. And one of the very prominent differences that Tilman will surely enlighten us about is the question of the hurdles concerning the validity of the patent issue. Whilst the German courts have traditionally applied a very strict criterion and wanted to make sure that they only grant injunctions on patents or utility models that have a high degree of probability to remain valid, the UPC takes a very different and much more relaxed approach.
Okay, well then that's a good onward pass to Tilman. So Tilman, with the validity check in the PI proceedings, Tilman is in the first months of the UPC practice. We've seen some divergence on how the court assessed the likelihood of validity. What is the current line of thinking, and how much do you have to prove?
Yeah, well, in the early months of the UPC, we have seen some divergence across local divisions. Now, this is more or less settled. Why? Because the Court of Appeal of the UPC has had their saying, and they, according to their recent case law, we have a clear trend towards a much more balanced approach, or in other words, in the end, the validity must be more likely than not. So what does that mean? You can understand this literally. Validity must have a likelihood of 51% or more. If you can show that, then at least from that side, your preliminary injunction will be granted, actually. Bottom line is the standards are, in my opinion, rather low, very certainly compared with the German standards, but also compared with many other jurisdictions in Europe.
Okay, Jasper, urgency is a certainty of relevance. Oh, that's pretty deep. So some feared that the UPC would require extremely swift action. How have the courts, especially the local divisions, been handling the urgency requirements so far?
That's a super interesting and really relevant question, George, because we are used from the national practices that preliminary injunctions are only granted if you can prove that you have taken all measures to comply with this urgency requirement that is actually codified in many of the national patent laws. For some reason, it's very interesting to note that neither the UPC agreement nor the rules of procedure explicitly require or stipulate urgency as a fixed requirement for handing out a PI. There is no fixed deadline in the law. The rules of procedure discuss urgency. It has to be taken into account as an aspect when the court assesses the request. In the rules of procedure in 209.3, you even find the cases of extreme urgency. And rules of procedure 211.4 dictates that unreasonable delays in seeking provisional measures should be taken into account, but it's left completely open what this really means. What kind of time windows are we talking about? And with the experience we have gained so far, we see striking differences between the different local divisions. I just would like to pick out the two most popular local divisions for PI requests. That is the local division of Düsseldorf and the local division Munich, which have so far handled the most PI requests at the UPC. The Düsseldorf local division has pretty much stuck to what they were usually applying in national proceedings. They usually apply a 1-month deadline. After becoming aware of the infringement, you should file your preliminary injunction application within a very short window of 1 month. This is the rule that the local division Düsseldorf applies in their current decisions. Of course, there are exceptions to the rule. We will come to that in a moment. But if you want to get a preliminary injunction at the Düsseldorf local division, you should act really fast.
Ooh.
As a comparison, if we look at the local division of Munich, which are the division to handle the most PI applications so far, they have explicitly stated in one of their decisions that they do not follow the Düsseldorf practice. They usually apply a time window of 2 months and say 2 months is sufficient from the act of infringement being noted by the proprietor up to the filing of the application. A 2-month window is usually acceptable. Of course, the specialties and peculiarities of the individual case have to be taken into account. There is one very interesting decision taken by the local division of The Hague. The patent was in the field of biotech. It was about a special mushroom culture. And when the patentee got aware of the infringement, it took them 12 months to gather the evidence required for filing the PI request.
Okay.
Because you had to cultivate the mushrooms, you had to have biological samples cultivated and then tested, and they explained in detail why they took 12 months to prepare the evidence, but they were able to prove that within these 12 months, no unreasonable delays were included. So for this reason, The Hague said this is completely acceptable. If you work in the field of biotech, sometimes 12 months is as fast as you can go, obviously. So to sum up, at the present, we have a lot of local divisions following the spirit of the local division Munich to apply 2 months as a rule of thumb, and the Düsseldorf division being very strict about this and applying a 4-week or 1-month deadline like they used to do in the national practices.
Tilman, I'm going to throw this back to you. Would you say the bar for urgency is higher or lower than in, say, Germany?
I would say actually that the bar for urgency is higher in Germany. In other words, that the UPC is more liberal in its approach or in its evaluation of that criterion. There's one specific case, a very, very important case also for many other reasons, in Abiot versus Sibio. There, the Court of Appeal decided on, very recently actually, 14 February 2025, on a preliminary injunction case and also elaborated on the urgency requirement. And they actually said, well, if, as in that case, the infringement is found, I would say, in December 2023, a request for a preliminary injunction in March 2024 was still in time. However, for some other reasons, they said, well, it was necessary to perform some X-ray analysis and so on. But still, in the end, the time frame between, let's say, the end of the evaluation on the X-ray analysis side and filing the request was more than 1 month. So what can be clearly taken from that decision is that 1 month is not a definite criterion. As Jasper said, it's also not in the law, and there are local divisions which are anyway more liberal. So what you can say, 1 month is not as determinative as, for example, in some district courts in Germany, actually. And also, very much like in the mushroom case, the Court of Appeal in that case was willing to accept that, of course, as a patentee, you want to make your case bulletproof. And therefore, even if the X-ray analysis was not even necessary in the end, they accepted this behavior in the end. So
yeah, as a patentee, you simply have to be prepared to make a very clear case for yourself, and you really have to explain in detail why it took you so long to file the injunction. If you have the good arguments on your side, Tilman, I think this is the way to go. Don't be silent about it. Be very transparent and clear about it in your application.
Yep, totally agreed.
It's like a job interview, you know? You present your CV and your new employee says, well, what did you do in 2024? There's no activity here. And you say, well, I was on vacation for a year. Well, this is a problem in your CV, and it's the same for PI applications. If you have gaps in the chain of events leading from the detection of the infringement to the filing of the request for preliminary injunctions, that's a problem. If you can clearly say, well, look, this is a very highly specific case. We had to get expert opinions. We had to make very difficult investigations by some kind of expert institute. It took them 4 weeks to conduct the measurements, and this is just common in the field. You will be fine. You just have to have a clear explanation.
The rule of thumb, I would, however, still say, I mean, from the time where you have bulletproofed your case to actually filing the request for a preliminary injunction, you should not spend more than 1 month. Maybe even less, but I would still say maybe the Court of Appeal in the one case accepted also 1 month and some days. But I would not risk this. So 1 month from the date where you actually can prove the infringement.
Tilman, how fast is fast? Have we already seen cases where the UPC acted within days? And are ex parte PIs realistically available?
How fast is fast? I think, Jasper, you mentioned before that the one case where the Düsseldorf division, I think it was, granted a preliminary injunction within a day. And so the UPC is extremely fast in this regard. I mean, this is a technical protection right we're talking about. So it's not a trademark or a design where you can look onto this. So you have really to understand the technology and the scope of protection. And if you count this, they are extremely fast. This is extremely impressive. And yes, I think you put also the question whether there are ex parte preliminary injunctions available. They are available. This is in the law. It's an UPC agreement. And also realistically available. There have been, I think, 3 cases, meanwhile, 2 from the Düsseldorf division, 1 the local division in Milan, granting an ex parte preliminary injunction, meaning a preliminary injunction without even hearing the other party. So the first time you learn from the preliminary injunction is actually when you get it at a trade fair.
On you.
All 3 cases were trade fair cases, as far as I remember.
Jasper, have you seen decisions where proportionality played a role? In general, how much room does the UPC give to defendants to argue business impact or public interest? Now, that'd be interesting.
Yeah, that's a super interesting legal question, which has given rise to substantial discussions actually across the globe, but then, of course, especially in Europe when the UPC entered into force. The interesting thing to note is, George, that if you look at Article 62 of the UPC agreement, which codifies the preliminary injunctions, there is no requirement to take proportionality into consideration when handing out preliminary injunctions, whereas for other measures, it's explicitly in the UPC agreement that proportionality has to be taken into consideration, which is somewhat surprising because a preliminary injunction is about the sharpest weapon you have in your arsenal for hitting your potential infringer, because as Tilman has just said, within 1 day, ex parte proceedings, you're not being heard, and then you're facing a preliminary injunction with injunctive relief. You have to stop committing the infringement. That's a very harsh situation. And of course, we should be able to argue proportionality. Is this really the right tool to reflect the best interests of all parties and the public involved. Luckily, we know that the principle of proportionality is recognized as a fundamental principle under EU laws. And of course, the UPC is bound to EU law. So implicitly, proportionality has to be taken into account, of course, also when deciding on preliminary injunction requests. So some decisions that we have seen so far explicitly take into consideration such arguments. Most of them are actually in the automotive sector. You have a very complex product and you have a chain of delivery to finish the car. You have a patent holder who assumes infringement of a very specific part of the more complex product, the car. And if you were to file a preliminary injunction, and if the UPC were to grant this and say you have to stop delivery of this part to the car manufacturer, this would be a very disproportionate effect on the car manufacturer because there is many regulations that you have to take into consideration. You cannot simply switch the supplier from one day to the other. So the PI would really have the effect that a third party that is not even involved in the whole discussion would be at a very high economic damage. And in these cases, we have seen this in Düsseldorf and also from the Court of Appeals, what they do in such cases, and this is, in my opinion, a very appropriate tool. They limit the scope of the injunctive relief. They say you can still deliver the parts to some limited extent. However, in order to compensate for the patent infringement, you have to pay an adequate financial compensation, which they can set at a reasonable value. So the patent owner still gets compensation for the infringement of his patent without having an overly negative impact on the public or third parties.
Tilman, can defendants request securities or countermeasures? And how does the UPC balance that with the rights of the patentee?
The UPC has, I would say, consistently ordered securities under Rule 211, paragraph 4 of the Rules of Procedure, practically in the form of a bank guarantee or actual direct payment to the court to cover potential damages if the preliminary injunction is later revoked. So the courts try to strike a fair balance, on the one hand, giving weight to the patentee's exclusive rights, on the other, protecting the defendant against unjustified injunctions, of course. The amounts, by the way, vary extremely. We have seen securities in the millions, and we have also seen securities like 50,000. So it's difficult to anticipate what to expect. But anyway, yeah, there will be security.
Then forum shopping and division strategies. Jasper, do we already see patentees favoring certain local divisions for PIs? And what are the go-to divisions so far?
Well, if you look at the official numbers, which have been issued only 4 weeks ago, we see a very clear trend lately. Munich is really emerging as the prime division for handling preliminary injunctions. So at the end of February 25, there was a total of 56 preliminary injunctions being handled by the UPC, of which 23, so roughly 30%, were handled by Munich.
Okay.
The second popular division is Düsseldorf and Hamburg, each with 9 PIs.
Okay.
And the next one that sticks out a little bit is The Hague with 3.
Okay.
So, but from a feeling, I would say that there is a clear preference for Munich and Düsseldorf. And interestingly, we have already touched upon this a little bit. The practice of handling PI applications before these 2 divisions is somewhat different. We have discussed the urgency requirement, where Düsseldorf, as a rule of thumb, applies a very strict criterion of 4 weeks, whereas Munich is more relaxed and has explicitly stated they will not follow the Düsseldorf case law. They will apply a more lenient criterion for the urgency requirement. However, it's also important to note, in my opinion, that so far we have not seen a single ex parte decision from Munich, whereas, as Tilman has already said before, Düsseldorf has already issued a few ex parte injunctions where the potential infringer was not heard before deciding on the preliminary injunction. So maybe this is also a little bit of a take-home message. If you're interested in ex parte injunction, probably the best chances you have at the moment are Düsseldorf. However, it comes at the cost of a very strict urgency requirement, which you have to make sure to fulfill it. And if you feel that you cannot meet the strict criterion of urgency with Düsseldorf, then probably at the moment Munich is a good place to go, because they frankly have the biggest experience in handing out PIs.
Excellent, excellent, understood. Tilman, any case you'd like to highlight as particularly instructive or surprising in terms of how the UPC approaches PIs?
Yes, there's the one case. Interestingly, by the way, it's originating from the Munich local division, but we are not talking about the decision of the local Munich division, but of the Court of Appeal decision or order, as it is called, based on that decision, which is extremely instructive. First, by the way, for reasons how claims should be interpreted, so a very basic and important aspect of any patent case, I would say. And secondly, also how to handle preliminary injunctions. The case is nanostring versus 10 times genomic, and the order everyone should read, I would say, for preliminary injunctions has been issued on the 26th of February 2024. And there we have learned the principles, which are still valid, of course, that infringement must be more likely than not, that validity must be more likely than not, and also other prerequisites. For example, the ownership of the patent must be more likely than not. And if everything is more likely than not, then the PI should be granted, at least in general.
Okay, then strategic takeaways for patentees. This should be good. Jasper, what are your top 2 practical tips for a patentee who wants to prepare for a potential PI request at the UPC?
The first practical tip is time is of the essence here. You really have to act quickly. When you suspect infringement, make sure to seamlessly document all steps from the detection of the infringement to the completion of your evidence gathering in order to be sure you can adhere to the urgency requirements, because this is, in my opinion, the biggest hurdle to face as the patent proprietor when applying for a preliminary injunction. And the second tip, we discussed this briefly in your last question, you should be prudent about the forum choice. It depends really on what you want to achieve. If you want to achieve the fastest possible PI ex parte without hearing the adverse party, then probably you should really opt for Düsseldorf at the moment, because they are so far the ones with the most ex parte PIs issued. And if time is not that much of an essence, then probably, as I said before, Munich is an interesting choice, since the case law is very well established with 23 decisions already available.
Then strategic takeaways for defendants. Tilman, same question for you, but from the perspective of the alleged infringer. So that's good. What should companies do to prepare and protect themselves?
Yeah, first of all, don't infringe. That sounds funny, but Europe is now a very difficult jurisdiction for potential infringers. Germany was always a difficult jurisdiction. Why? Because in Germany, it was always rather easy to get an injunction, be it a preliminary or a permanent injunction, more a permanent injunction. The UPC now is even more difficult for infringers because also preliminary injunctions are rather liberally granted. And what can you do to protect yourself? You can, and you should, think about filing a protective letter to the UPC. This can be done via the CMS, the case management system, and is in the end a letter where you anticipate a future preliminary injunction request, and in which you argue that you either don't infringe or the patent is not valid, and in any event that the court should please hear your arguments in an oral hearing or whatsoever. So the goal of such protective letter would be to avoid an ex parte preliminary injunction. And also, where you should be careful is reacting to a warning letter from the patentee. If you respond thereto, your response should be very detailed, and you should bring your actually best arguments. Why is that? Because we've had a case where an ex parte injunction was requested, and the patentee presented to the court the warning letter and the response thereto. And the court said, well, we have heard the arguments. We don't think that they are strong enough. So they granted the ex parte preliminary injunction. Again, your most favorite local division, of course, in Düsseldorf, George.
Well, thank you very much for bringing that up. Jasper, Tilman, thank you both for these sharp and strategic insights. It was a blast to have you guys on the show as always, and I hope you will come back. I know Tilman will be back. Jasper, we'll have to check out your schedule and beg you to come back. It's clear that while preliminary injunctions are a powerful tool, they also come with procedural and tactical complexities. So to our listeners, thank you for tuning in. And if you found this episode helpful, make sure to subscribe and share and leave us a rating. And of course, stay tuned for our next episode where we look at the role and the rise of protective letters before the UPC. Until then, I'm George Walden on behalf of Jasper, Werhahn, and Tilman, Pfrang. Hey, this was a great show, and this was UPC Insights. Take care. Until the next time, auf Wiedersehen.
Auf Wiedersehen, George.
Thank you so much.